The first thing I saw wasn't the mountains. It wasn't the crystal clear river winding through the valley. It wasn't even the dozens of luxury homes sitting where my grandfather's cattle used to graze. It was the sign. Welcome to Silver Ridge Estates, private HO, a community residence only. I stared at it for several seconds. Then I looked at the property deed lying on the passenger seat of my truck. The legal description matched perfectly. According to every county record, the land behind that sign belonged to me, all 2,500 acres of it, which raised one very important question. How exactly had an entire HOA convinced itself it owned land that had been in my family's name for nearly 70 years? 3 months later, that same sign would be lying in pieces on the back of a demolition trailer. More than 100 homeowners would be attending emergency meetings, and one judge would deliver a ruling that nobody in Silver Ridge Estates ever expected to hear. My name is Mason Walker. I'm 38 years old, a former Army Corps of Engineers project manager, and until recently, I thought my family's ranch had disappeared decades ago. Growing up, my grandfather used to tell stories about Eagle Valley. He described endless grasslands stretching between two mountain ridges, cold streams full of trout, wild elk crossing open meadows every autumn, thousands of acres where our family raised cattle for generations. Then came the stories about lawsuits, debt, poor investments. According to everyone in the family, the ranch had been lost sometime in the early 1980s. No one talked about it anymore. After my grandfather passed away, I inherited a small wooden box that had been sitting in his attic for decades. Inside were faded photographs, old survey maps, property tax receipts, letters from attorneys, and one sealed envelope with my name written across the front. I didn't open it immediately. A week later, curiosity finally won. Inside was a handwritten letter. Mason, if you're reading this, then I'm gone. Everyone believes we lost Eagle Valley. We didn't. We lost the ranch headquarters, the northern grazing land, several equipment barns, but not the valley itself. I kept one parcel separate, never sold it, never mortgaged it, never transferred it. Nobody remembered because nobody looked. If the records still exist, the valley is yours. Go see it before someone else decides it's theirs. Love, Grandpa. I honestly thought the letter might be mistaken. 40-year-old memories aren't always accurate. Still, I visited the county recorder's office. The clerk searched the archives for nearly an hour. Finally, she stopped, looked at me, then looked back at the screen. That's unusual. What is? This parcel hasn't changed ownership in 68 years. She printed the records, every transfer, every tax payment, every survey. My grandfather had been telling the truth. The 2,500-acre valley had remained in our family's name the entire time. Even stranger, property taxes had continued being paid through an automatic family trust established decades earlier. Nobody realized the trust still existed, not even my parents. Legally speaking, I now owned one of the largest privately held valleys in the county. 2 days later, I drove there. The first 20 miles matched every story Grandpa had told. Rolling hills, open meadows, beautiful river crossings. Then I rounded one final curve and nearly slammed on the brakes. A luxury gated community stretched across the valley floor. Beautiful stone entrance, landscaped medians, private roads, a clubhouse, swimming pool, tennis courts, walking trails, playgrounds, more than 100 expensive homes. I checked the deed again, then my GPS, then the county parcel map. There was no mistake. The subdivision had been built directly inside my property boundaries. I drove toward the entrance. A security guard stepped out of a small booth. Residents only. I own this property. He smiled politely. I've heard that joke before. I'm serious. This community belongs to Silver Ridge Estates. No, it belongs to me. He laughed. I don't think so. I showed him the deed. He barely glanced at it. Take it up with the HOA. I plan to. The clubhouse looked like a luxury resort. Inside, the monthly board meeting had just ended. The HOA president introduced herself. "I'm Linda Foster. I'm Mason Walker. How can I help you? I believe your entire subdivision sits on my land." She smiled the way people smile when they think someone is confused. "I'm afraid you've been misinformed." "I don't think so." I placed certified copies of the deed on the table. She skimmed the first page, then pushed the papers back. "Our attorneys handled everything years ago." "Wonderful. I'd like to meet them. They'll tell you exactly what I'm telling you." "I hope so. Because if they couldn't, things were about to become very expensive." As I left the clubhouse, an elderly resident quietly caught up with me. "Young man." "Yes? I've lived here 21 years. "I see. I've always wondered something." "What?" "When they built this place, they never finished buying all the land." I stopped walking. "What do you mean?" "They kept saying the paperwork would be completed later." "Who said that?" "The original developer." "Did it ever happen?" He slowly shook his head. "I don't know." That single conversation changed everything. The problem might not be the homeowners. It might go back to the developer who built the neighborhood decades earlier. The next morning, I hired a title company specializing in historical land records. I also retained one of the state's best real estate attorneys. 3 weeks later, both called asking for an emergency meeting. Neither sounded excited. They sounded shocked. When I arrived, my attorney spread dozens of documents across the conference table. "Mason, what did you find?" He looked directly at me. "The HOA doesn't own your valley." I expected that. He slowly nodded. "But here's the part nobody saw coming." He slid one yellowed document across the table. "The developer never owned it either." I stared at him. "You're saying they built an entire subdivision?" He finished my sentence. "On land they never legally purchased." The room fell completely silent. Because if that document was authentic, one of the biggest property mistakes in the county's history had just been uncovered. And before long, every homeowner in Silver Ridge Estates would discover that their million-dollar homes stood on land that had never legally belonged to the developer in the first place. I didn't sleep much after that meeting. My attorney's final sentence kept replaying in my head. "The developer never owned your valley." If that was true, this wasn't just a property dispute. It was one of the biggest title failures anyone in the county had seen in decades. The following morning, our legal team met with the title company that had spent weeks digging through archived records. Boxes filled with old surveys, handwritten deeds, tax maps, and courthouse filings covered the conference table. The lead examiner, Patricia Ellis, pointed to a yellowed document dated 32 years earlier. "This," she said, "is where everything went wrong." She explained that the original developer, Silver Ridge Development Corporation, had negotiated to buy several thousand acres from multiple landowners. Most of those transactions closed successfully. One didn't. My family's 2,500-acre valley. The purchase agreement had been drafted. Initial payments had even been discussed, but the final closing never happened. The seller, my grandfather, refused to sign after discovering changes to the contract. The deal collapsed. The developer moved forward anyway. Somehow, the roads were built, utilities were installed, building permits were issued, homes were sold. The subdivision expanded year after year, yet the Central Valley parcel had never legally changed ownership. Patricia slid another document toward me. "The county tax records continued billing your family trust the entire time. And nobody noticed?" "They noticed." She looked toward my attorney. "They simply assumed it would eventually be corrected." My attorney frowned. "They built an entire community based on an assumption." Patricia nodded. "It appears so." A week later, we requested a meeting with county officials. The county recorder, the planning department, the building division, the county attorney's office. Everyone received copies of the title report before the meeting. Judging by the expressions around the room, most had already realized how serious the situation had become. The county attorney spoke first. If these records are accurate, he paused. We have a significant legal problem. The planning director looked almost embarrassed. How did this happen? No one had an answer. The subdivision had changed hands multiple times. Developers merged. Companies dissolved. Employees retired. Records moved from paper files to digital archives. Somewhere during those decades, everyone assumed someone else had verified ownership. Nobody had. The county attorney turned to me. Mr. Walker, what outcome are you seeking? It was a fair question. I'm not trying to punish families who bought homes in good faith. Several people relaxed slightly. My issue isn't with the homeowners. I pointed toward the title report. It's with the people who ignored property ownership. The county attorney nodded. I appreciate that. Later that afternoon, news of the investigation spread through Silver Ridge Estates. Residents flooded the HOA office demanding answers. An emergency town hall meeting was scheduled that evening. More than 200 homeowners packed the clubhouse. Linda Foster stood behind the podium, looking noticeably less confident than during our first meeting. I know everyone has questions. Hands shot into the air immediately. Is it true we don't own the land? Are our homes illegal? Can we lose everything? Linda raised both hands. We're consulting legal counsel. That wasn't enough. People wanted facts, not promises. One homeowner stood. We've invested our life savings here. Another added, my family has lived here for 18 years. An elderly couple quietly asked, could someone actually force us to leave? No one on the HOA board answered, because they honestly didn't know. The following week, my attorney filed a formal quiet title action asking the court to officially confirm ownership of the valley. It wasn't an eviction. Not yet. It simply asked the court to determine who legally owned the land. The answer seemed obvious based on the records, but courts require evidence, not assumptions. Within days, survey crews arrived. Professional engineers located the original property monuments placed nearly 70 years earlier. Some markers were still exactly where my grandfather's surveyor had left them. Others had been buried beneath landscaping and sidewalks. Each recovered marker confirmed the same thing. The subdivision's entrance, the clubhouse, the swimming pool, the tennis courts, walking trails, maintenance buildings, and dozens of homes. All stood inside my family's legal boundary. Television news crews began appearing outside the neighborhood gates. Reporters interviewed residents. Most homeowners were frustrated. Not with me. With the developers who had sold them homes without resolving ownership first. Then something unexpected happened. An elderly man named Harold Jensen asked if he could meet me. We sat on the porch of a small cafe outside town. Harold had worked for Silver Ridge Development during the earliest construction years. I've carried this around for almost 30 years. He handed me a worn leather folder. Inside were copies of internal memos, meeting notes, letters between company executives. One memo caught my attention immediately. It was marked confidential. The final paragraph read, proceed with Phase 1 construction while negotiations continue. Legal believes ownership issues can be resolved later. I looked up. Did they know? Harold nodded slowly. They absolutely knew. Why are you bringing this forward now? He looked out the cafe window toward the mountains. Because the people living there deserve the truth. Those documents changed the case overnight. Until then, the developer's actions might have been explained as negligence. Now there was evidence suggesting they knowingly moved forward before securing ownership. The county attorney requested copies immediately. State investigators also became interested. The original development company no longer existed, but its successor corporations still held certain financial records and insurance obligations. Several law firms suddenly found themselves reviewing files nobody had opened in decades. Meanwhile, life inside Silver Ridge Estates became increasingly tense. Residents worried about property values. Real estate agents quietly canceled listings. Banks delayed mortgage approvals. Insurance companies requested updated legal information. No one knew what would happen next. Despite the uncertainty, I continued saying the same thing whenever reporters asked for comment. I'm not at war with the homeowners. I want a lawful solution. Some residents appreciated that. Others remained skeptical. Then, one Friday afternoon, my attorney received a call from the HOA's legal team. They wanted to negotiate. We met the following Monday. Linda Foster attended with 2 attorneys and several board members. The meeting lasted nearly 4 hours. Their lead attorney finally asked the question everyone had been avoiding. If the court confirms you own the valley, what do you intend to do? I answered honestly. I'll consider every lawful option. Would that include eviction? It could. The room fell silent. One board member leaned forward. You're talking about more than 100 families. No, I replied calmly. I'm talking about a legal problem that began decades before any of us arrived. The negotiations ended without an agreement. Both sides prepared for court. Experts were retained. Surveyors finalized maps. Historians authenticated old deeds. Title specialists prepared testimony. The courtroom schedule quickly filled with witnesses. Then, just 2 weeks before trial, another shocking discovery surfaced. The county found evidence that the original developer had used my family's land as collateral in financial documents, despite never holding legal title to it. That revelation stunned everyone involved, because it suggested the ownership issue wasn't simply overlooked. It may have been ignored repeatedly. As opening statements approached, one thing became clear. The judge wouldn't just decide who owned the valley. The court would determine what happened when decades of assumptions collided with documented property rights. And whatever the decision, it would change the future of Silver Ridge Estates forever. The courthouse had never seen anything like it. By 8 o'clock that morning, every seat inside the largest courtroom was filled. Homeowners from Silver Ridge Estates sat shoulder to shoulder. Local reporters lined the back wall. Surveyors, title experts, real estate attorneys, county officials, and curious residents from neighboring towns all waited for the hearing to begin. No one was smiling. For the families living in Silver Ridge Estates, the outcome could determine the future of their homes. For me, it was about something much simpler: property rights. The judge entered precisely at 9 o'clock. After reviewing the case file, he looked around the packed courtroom. This court understands the significance of today's proceedings. He paused. But public interest does not change the law. My attorney, Rebecca Lawson, stood first. She didn't begin with emotional arguments. She began with facts. Your Honor, ownership is established through recorded deeds, lawful transfers, and verified title, not assumptions. She displayed a timeline stretching nearly 70 years. Every recorded deed, every tax payment, every probate document, every trust record, each pointed to the same conclusion. The Walker family had never transferred ownership of the 2,500-acre valley. Next came the county recorder. She confirmed that no deed conveying the property from my grandfather, or anyone in my family, had ever been recorded. Then the chief title examiner testified. She carefully explained the chain of title. There were no gaps, no missing signatures, no forgotten transfers. Just one simple fact: the land had always remained in my family's ownership. The HOA's attorneys argued that the homeowners had purchased their properties in good faith. Rebecca agreed. They absolutely did. The courtroom became quiet. She continued. This case is not about blaming homeowners. It's about determining who legally owns the land beneath their community. That distinction mattered. The judge nodded. So noted. Then came the survey evidence. Large maps covered nearly the entire courtroom display. Original survey markers, modern GPS measurements, historical boundary records. Every independent expert reached the same conclusion. Silver Ridge Estates had been constructed inside the Walker family parcel. The evidence wasn't close. It was overwhelming. The most dramatic testimony came from Harold Jensen. The retired project superintendent slowly walked to the witness stand, carrying the same leather folder he had shown me weeks earlier. He took a deep breath. I worked for Silver Ridge Development during Phase 1. Rebecca asked the first question. Did company executives know they had not completed the purchase of Mr. Walker's family property? Harold looked toward the judge. Yes. A murmur spread through the courtroom. He continued. I attended meetings where executives discussed continuing construction while hoping ownership would be resolved later. Rebecca held up the confidential memo. Is this one of those documents? It is. The memo was admitted into evidence. The judge spent several minutes reading every page. Then he looked toward the HOA's legal team. Do you dispute the authenticity of this document? Their lead attorney stood. No, Your Honor. That single answer changed everything. The courtroom fell silent. Next, the county planning director testified. He admitted that permits had been issued decades earlier based on incomplete title verification procedures that no longer existed today. It should have been caught. Was it? No. The original title insurance company also appeared. Representatives acknowledged that historical mistakes in title review contributed to the problem. Several insurers indicated they were already working with homeowners regarding potential compensation if the court confirmed my ownership. For the first time, many residents looked relieved. They realized they weren't necessarily facing financial ruin. The legal system had mechanisms to address mistakes made decades earlier. Then it was my turn. Rebecca asked only a few questions. Mr. Walker, why did you bring this case? Because my grandfather trusted that property rights meant something. What have you consistently told the homeowners? That they're not my enemies. If the court confirms your ownership, what do you want? I answered honestly. A lawful solution. Not revenge. No. The judge wrote something in his notes. The HOA president, Linda Foster, testified afterward. To her credit, she admitted that the current HOA board had inherited the problem. We believed everything had been handled properly. Rebecca nodded. I believe you. Linda looked surprised. Rebecca continued. But believing something doesn't change ownership. It doesn't. Closing arguments lasted less than an hour. Rebecca summarized the case in one sentence. No matter how many homes are built, no one can legally sell land they never owned. 2 weeks later, the courtroom filled once again for the ruling. The judge began by acknowledging the extraordinary circumstances. This case represents a profound failure of historical land transactions, title verification, and development oversight. He paused before continuing. However, this court cannot rewrite property law to correct mistakes made decades ago. He officially declared that legal title to the 2,500-acre valley remained with the Walker family. The courtroom became completely silent. Then he addressed the homeowners. The residents of Silver Ridge Estates purchased their homes in good faith. They are not responsible for the original developer's conduct. The judge ordered additional proceedings to resolve the practical consequences in accordance with state property law. Over the following months, those proceedings resulted in a comprehensive settlement. Rather than forcing families from their homes, a court-supervised agreement was reached. Insurance carriers, successor development companies, and financial institutions contributed to a compensation fund. Independent appraisers established fair market values for the land. After months of negotiation, I agreed to sell the portions of the valley occupied by the residential neighborhood at court-approved market value. The proceeds came through the settlement structure rather than from individual families alone. The homeowners retained their homes. The legal title was finally corrected. The HOA remained, but only after being completely reorganized under new leadership. The old entrance sign was removed. A new one replaced it. It read, Silver Ridge Estates, established by court-approved settlement. Linda Foster resigned after thanking residents for their patience. A new board focused on transparency instead of assumptions. As for the remaining valley, more than 2,000 acres of forests, rivers, and open meadows, it stayed exactly where my grandfather had always hoped it would. In the family, I restored old cattle trails, repaired historic fencing, partnered with local conservation groups to protect wildlife habitat. Sections of the valley were opened for guided educational tours so local students could learn about the region's history. One autumn afternoon, I stood beside the same river my grandfather had described when I was a child. The mountains reflected across the water exactly as they had in his faded photographs. I unfolded his final letter once more. The last sentence caught my attention. Take care of the valley, and it will take care of you. For the first time, I truly understood what he meant. This story was never about throwing families out of their homes. It wasn't about humiliating an HOA. It wasn't even about winning a lawsuit. It was about proving that the rule of law protects everyone. It protects the family that keeps careful records. It protects the couple who unknowingly bought a home. And it creates a path to resolve even decades-old mistakes fairly. Because ownership isn't determined by assumptions. It isn't created by fences, signs, or neighborhood meetings. It begins with the law. And the law, when applied fairly, can protect both justice and community at the same time. If you enjoyed this story, don't forget to like, share, and subscribe to the channel for more powerful HOA stories, courtroom drama, property rights battles, justice-served stories, and unforgettable endings every week. Turn on the notification bell so you never miss our next story. Thank you so much for watching, and we'll see you in the next video.